Hello, everybody, and many thanks for joining us today in this first meeting of what we're referring to as our lunch bite seminar. So for those on European time, that will make sense. For those joining outside Europe, we at different times of the day. I hope you can appreciate what we're trying to do is create a short and accessible way to promote engagement between research and policy. And my name is Andrew Geddes. I'm the director of the Migration Policy Centre at the European University Institute in Florence. And I also coordinate a project which has the acronym of Innovate, but is actually what it's designed to do is promote better engagement between research evidence and policy, and to bring into dialogue evidence, people involved in the production of evidence and people involved in policy roles. So you're very welcome to the first of our Lunch Bites seminars. And today the focus for our discussion is on sustainable transitions for Ukrainians displaced following the full-scale Russian invasion of February 2022. And this is a very timely issue because we know that we've just 1 year left until March 2027 when the directive will expire. The question of protection of Ukrainians is very pressing. So the Temporary Protection Directive did offer swift and collective protection to millions of displaced Ukrainians. And what we've seen recently is Council and Commission guidance, which sketches possible post-2027 pathways that could include national residence permits, support for voluntary return. But there's still critical gaps that persist because many beneficiaries or potential beneficiaries might not meet integration-based criteria for long-term permits, nor be able to return safely while the conflict continues. So what we have is, in a way, an unresolved space, which is creating the risk of placing heavy pressure on national asylum systems and creating protection gaps and legal limbos. So addressing this requires more than legal options alone. What it requires is a grounded understanding of people's trajectories, capacities and constraints, and a realistic assessment of administrative and political feasibility across member states. And this is precisely where research policy dialogue becomes indispensable, the kind of things we're trying to develop in the Innovate project, because evidence can illuminate who is likely to fall into the gaps and also allow us to understand the transition models that have been applied elsewhere and how different scenarios in the future can affect systems and individuals. But at the same time, policy perspectives are vital because they help us to think about and refine research questions and also ensure that proposed solutions are implementable, coherent, and aligned with broader EU objectives. So that's the focus of today's meeting. And I'm delighted to welcome to the meeting Elena Gobbetti, who is a policy officer in the Asylum unit at DG Home within the European Commission, and Meltem İneli Ciğer, who is an associate professor of international law at Suleyman Demirel University in Turkey and also a partner in the Innovate project. And the aim today is to discuss evidence-based and sustainable transition pathways for the post-Temporary Protection Directive landscape. So the format is as follows. I'm rather than presentations, what I'm going to do is put a couple of questions each to Elena and Meltem. And I think that will probably take around 20 minutes or so for this conversation. And then we'll open it up for Q&A. And if you do want to participate in the Q&A, please put your questions into the chat box. So we greatly appreciate you joining us. And without further ado, I'd like to open the discussion. And first of all, I'd like to put the question to Elena Gobbetti, say from DG Home. And the question for Elena is to ask, well, what approach does the Commission intend to take to ensure a smooth transition for Ukrainians when temporary protection expires in March 2027? And what long-term residence or return pathways are being considered at EU level? So over to you, Elena.
Thank you very much, Andrew, and good afternoon, everybody. I hope you can see me and hear me well. If not, just please signal. I think this is a very interesting question, and perhaps the key word in this question is actually smooth when it comes to the smooth transition, because as Andrew already anticipated a bit, in June last year, the Commission proposed as part of the package a proposal for a Council recommendation on the coordinated and sustainable transition out of temporary protection that touched both upon transition to other legal statuses on one side, in complementarity with the return to the country of origin, meaning to Ukraine, of course, in this case, when actually conditions will allow for it. I think, so what we've seen so far, so as you know, I think the transition, when it comes to the Council recommendation, the recommendations related to transition to other statuses are those which in principle are supposed to be implemented already before the end of temporary protection. So not to wait until the end of the protection and to, in a way, have legal gaps, because of course we don't want people to be irregularly staying, so to find themselves in an irregular situation in the EU. So the encouragement that we give there is really to do this transition before temporary protection ends, bearing in mind that, of course, if these people transition and then they need to still be protected and they lost basically the legal basis for residing in the EU on another legal, with another legal status, they can always come back to temporary protection while temporary protection is active. I think I will start by saying, because you also refer to long-term residence statuses, other pathways at EU level. The main reason, for example, why not examining and exploring the option of EU residence permit, of EU card that would cover all beneficiaries of temporary protection at EU level. It is because we don't have a legal basis at EU level to provide for such a unique solution, and therefore we have to resort, unfortunately, to the solutions that member states themselves will implement. Secondly, the Council recommendation talks about a bit more of a coordinated approach rather than harmonized approach, and this is a bit the difference here, because here the coordinated approach means that everybody goes into the same direction, as to provide transition, as to returning people to Ukraine when conditions allow, but at the same time, because of the fragmented approaches and differences between member states, we also need to ensure that this transition is managed by, for example, what is already present under the national law or new solutions. When it comes to transitions, I think we identify three main possible solutions, which transition to other national statuses, so those already present in the national legislation. Second is to provide a kind of a bridge to certain EU legal migration directives, which is not possible, which is not normally the case. And the third one is actually dedicated residence permit. I think what we've seen so far, and this I can give you my view compared to when we actually adopted the proposal and the Council recommendation, there have been, I think, quite some progress since the recommendation and even before towards this different solution. But of course, as you might have seen, there are some member states, for example, like Poland, like Czech Republic, who are adopting this dedicated residence permit, mostly trying to cover all beneficiaries of temporary protection, while some other member states will just resort to what is already available under the national legislation. I think the challenges that we might see there, and this is why I put the emphasis on the smooth transition, is because a couple of challenges that we've been seeing since 2022 is, one, the fact that persons, for example, work in low-skilled jobs. So there is a kind of a skills mismatch of people. And the second one is also partially due to this, is that people will not everybody will be able to meet, for example, the requirements to transition to a national legal status, especially when it comes to employment, I would say. So when it comes to this residence option, other pathways, I think at EU level, what we've been trying to do is to basically provide for whatever alternative that is there. The real challenge will be that also the residence permit will be a bit different. Of course, from the Commission perspective, what we said in the proposal and what it has been cleared out as well to member states is actually the person should have more or less the same rights. And according to us, these rights will be the same as under the temporary protection. Otherwise, there would also be less incentive to move to another residence status, another pathway. etc. But when it comes to, for example, the type of the residence permit, I think there we will be seeing some differences. And I think I will anticipate one of the questions, and then I will close it, is the residence permit for vulnerable persons, because of course vulnerable persons will not be able perhaps to transition to statuses based on employment or education. And there is the risk there, I think, that member states might want to go towards, permit based on humanitarian grounds, which normally gives less rights compared to temporary protection. So this is also one of the things we've been trying to work out with member states. I think perhaps I will stop here to keep the intervention short and for questions later on, but just let me know, if you want me to expand a bit. Thank you.
Thank you, Elena. That was a fantastic start. And just to reinforce the point that Elena made, if you do have questions, please put them into the chat box. We'll have plenty of time for a Q&A at the end of the session. After the interventions from Elena and from Meltem. So now I'd like to move to Meltem as a associate professor of international law, and really thinking about the kind of the perspective that you've derived from the work that you've done over the years, to think about how the EU's activation, repeated extension of a temporary protection directive reshapes legal boundaries between emergency protection and long-term residence rights, and to get your perspective on what effects this might create for future mass influx situations. So over to you, Meltem.
Thank you, Andrew, for the question, and thank you, Elena, for outlining the Commission's current trajectory and the Council recommendation. While the implementation of the Temporary Protection Directive since 2022 is an undeniable success and has many elements that are very positive, as a legal academic, I must address the elephant in the room. The 3-year maximum duration established by the directive, including Article 4, it is not being respected. By extending the status to March 2027 without a comprehensive and, as Elena mentioned, not uniform exit strategy that is tailored for all temporary protection beneficiaries, I think the Commission and the Council risk leaving certain displaced persons from Ukraine in a state of legal limbo. Now, I will explain very briefly why. First, the Temporary Protection Directive was designed as an exceptional time-limited response to mass influx, not a permanent alternative to international protection or long-term residency. Article 4 is straightforward. Temporary protection cannot exceed a maximum of 3 years. By extending protection until March 2027, the Council and the Commission, with its proposal, has bypassed the statutory limit without a legal basis in the text. There is virtually no academic consensus or view that these yearly extensions are legally justified. This transforms temporariness into a legal fiction, creating a precarious gray zone where an emergency status becomes a de facto long-term stay, leaving beneficiaries when temporary protection is terminated in a legal limbo. The ongoing conflict, of course, as the Commission reasons, justifies continuous support for Ukrainians, but the conflict alone is not a legal reason to ignore a maximum time limit provided explicitly in Article 4, including paragraph 2. Once maximum time limit passes, the regime should give way to durable solutions tailored for refugees. We don't know, because individual status determination is not applied for Ukrainians, but as an academic working on international protection and temporary protection for many years, I can say that many Ukrainians now, due to ongoing full-scale invasion, may qualify for the refugee status and subsidiary protection status. Therefore, we need to think about durable solutions available for refugees. First, repatriation. Durable as a durable solution, unfortunately currently impossible due to ongoing conflict. Resettlement inapplicable, as EU member states are developed states that do not need resettlement stored. This leaves local integration as the only durable solution. Ideally, the 3-year time limit should have been respected by transitioning members, temporary protection beneficiaries into stable resident permits or group-based international protection status. But by disregarding these 3-year time limit, the EU set a very dangerous precedent. if the Union does not comply with the timeframes set in its own directive for this derogation regime, and temporary protection is generally a derogation regime, it's suspension of the Refugee Convention, it invites doubt as to whether time limits in other crisis responses, such as the crisis and force majeure regulation, will be observed in the future. Therefore, this raises a serious question relating to legal predictability and legal precision within the Union policies responding to future crises. A major issue that these yearly extensions ignore is also the reality of integration. Many Ukrainians are now living in the EU for many years. They have been de facto integrated to the host communities. They have gone to school, they learned the language, found jobs, and this is an important issue. Therefore, the fact that the currently long-term residence directive excludes temporary protection beneficiaries from its scope is a problem that should be addressed. We know that the recast is ongoing, and the Commission has proposed to amend this to include temporary protection beneficiaries to the scope of the long-term residence directive, but we should see the consequence, and they should be applied. This should be all the more pressing if the Commission extends temporary protection beyond March 2027, which Elena in previous talks mentioned that this is also a possibility. Now, member states are increasingly encouraged to offer resident permits, as Elena mentioned, based on national laws or EU migration instruments such as Blue Card Directive, Research, or Single Permit Directives. But in my opinion, this creates a binary logic where residency is only offered to those that fit strict socioeconomic markers, such as high-level employment or education. This approach neglects a substantial residual group, as Elena mentioned, some vulnerable communities, including elderly, persons with disabilities, and those women with care responsibilities, single parents who may not earn required by these directives or national criteria. Therefore, for these groups, the end of temporary protection represents a cliff edge where they are barred from long-term stay, yet safe returns remain impossible. And without a transitional mechanism, this vast cohort will have no legal recourse other than to apply for asylum and international protection in the member states. This would lead to several systematic failures. Asylum systems will be overloaded. The administrative gains made by activation of the Temporary Protection Directive in the first place will be pretty much lost or reversed. And fragmented national approaches between member states may lead to secondary movements. I think this is also a very well-known fact. So this will, and consider this will be March 2027 earliest, this pressure will compromise the effectiveness of the newly implemented new pact on migration and asylum at the time. So ideally, what can be the solution? The most effective and legally sound approach is collective transition to either international protection or a durable and stable residency status in the member states. We have learned from Elena, some member states are doing that, but not all member states will follow this. I know from my own experience and communication from with different member states. And if such a collective transition is not possible, a group-based a vital alternative is to provide administrative bridges to up to 2 years, perhaps, to give temporary protection beneficiaries a right to choose between return or try to find alternative venues to stay through international protection or through residency statuses. I will perhaps can elaborate it further in the next round of questions. Thank you.
Thank you, Meltem. And I was going to, the next question, go back to Elena, and then maybe points that Elena wants to respond to from what Meltem has said. But I also wanted to ask you an additional question, Elena, which is, and it picks up on an issue that Meltem has raised, which is how the Commission will support member states in maintaining adequate reception, integration, and labour market access for beneficiaries during the extended period of temporary protection, given the scale and duration of displacement. So back over to you, Elena.
Yes, thank you very much. Perhaps I will start by replying to the second question, and then you let me know when I should address some of the points that were brought up concerning the the action at EU level. So when it comes to reception capacity, integration, and labor market access, I think we all agree on the fact that this is pretty much has an impact or an influence on the post-2027 scenario, especially when you look at the implementation of the Council recommendation, because I think if even though the mass influx is not as big as it used to be in 2022. There are still people fleeing Ukraine, of course, so more people come to the EU, more is necessary to provide for accommodation, integration, reception capacity, access to labor market to a considerable big number of persons. Also in consideration, as we just said, the temporary protection has been prolonged already until March 2027. When it comes to support in terms of funding, for example, there was the latest financial framework revision that says basically allocated 3 billion for the pact to deal with the pact on one side and with the reception, with the hosting of displaced persons from Ukraine. On the other side, of course, this alone is not going to solve the issues. I think we all have to be honest here. What I identify as the main drive of this action is actually the labor market access and the fact that people will need to become self-reliant, because of course we've seen many situations, as also Meltem has said, of women with children, and if you have to take care of your own children, then you cannot be engaged in the labor market. So I think this is the point where we actually have to insist, because the more self-reliant is the person, the less there will be the need to resort of, for example, state accommodation, state reception capacity. This, of course, implies as well that member states will have to step up a bit when it comes, for example, to language courses, integration in the labor market, acquiring skills, etc. And I think this is not only for the sake of integrating them in the labor market, being self-reliant, and perhaps integrating them in the host society on a more longer-term basis, but also because, as we said, transition to other statuses, remaining in the EU and returning to Ukraine, they are not alternatives. They can be complementary pathways, because if a person acquires new skills now and then is able to integrate in the labor market to find themselves, a new life in the host society, it cannot be excluded that later on these new skills, this upskilling or whatever we want to call it, will be useful as well for the reconstruction of Ukraine when time will come. Here I actually agree a lot on a point, on the fact, and this is also one of the points on which the Council recommendation is based, is the informed choice of the persons. So it's not one or the other, but they will have to make the choice on whether now they want to stay in the member states or now or eventually want to return back to Ukraine. So I think, of course, this is reality that is influencing already a lot the action at EU level and member states when it comes to what we call solidarity fatigue, let's call it like that. And of course, is also will have an impact on the way out. But this is, in a way, this is also one of the reasons for us. I mean, of course, I represent the Commission, for us and the member states to do this transition, to try to move away from this temporary status to other situations that better reflect the situation of the persons in the host member states. Because as you just said, some persons have been here in the EU for 3-4 years. By now, they should be, if they want to stay, they should be integrated in the host society. They shouldn't be, in a way, non-self-reliant, because it's neither good neither for them nor for the host society of the member states, of course. So this is why the Council recommendation puts a lot of emphasis on this transition. And from the Commission side, for example, this is something that we've been encouraging since March 2023, since we had a communication on 1 year of temporary protection, because we know that the key to also move away from this temporary situation is the self-reliance of the persons. So that's it. I think I will stop here. Just let me know if I should react to some of the points, some of the other points now or later on.
Maybe later on, and because also we'll gather, and some people have already done this, if you do have questions and want to join the conversation, please put them into the chat box, and a couple already done this. I think this gives us, we'll have plenty of issues to discuss moving on. But I just wanted to put another question to Meltem. So for you, Meltem, we're interested to know your perspective on the legal constraints and we're thinking about the legal constraints and competencies that shape the EU's ability to design a post-2027 framework for Ukrainians, and how do these interact with member states' obligations under EU law, the ECHR, and international refugee law? So back over to you, Meltem.
Right. Thank you, Andrew. I think this is a very good question. Well, the Union has policy discretion on how temporary protection can come to an end, and I think it has quite a wide discretion on designing exit strategies. Starting from the Temporary Protection Directive under Article 6, temporary protection ends when the Council decides so by a qualified majority that the situation in the country of origin proves and allows for a safe and durable return. And if this is not happened, then when the maximum time limit is reached. But since the Commission and the Council does not really respect this time limit, I think we know when temporary protection is terminated, when we know from the Commission and the Council. But in light of what I have said before, I think temporary protection should not be extended beyond March 2027. Instead, it should give way to durable solutions. Now, as Elena mentioned, EU lacks mandate to introduce a new EU-wide resident permit for Ukrainians. But as I mentioned, we already have the Long-Term Residence Directive. It should be amended to include temporary protection beneficiaries within its scope, or when 5-year limit is reached. I think I advocated for the introduction of some provisions in this directive that can actually facilitate transition of temporary protection beneficiaries into long-term residency directive, but we didn't see any proposal on that, so I think it's the kind of defunct. But I do not agree with Elena, in a sense that if somebody is not integrated so far, didn't learn the language or find the job, they can just be removed. I think this is legally a problematic statement, in a sense that we have the principle of non-refoulement provided by the Refugee Convention, by the European Convention on Human Rights and Human Rights treaties that the member states are a party of. And these kind of limit the member state and the EU discretion on designing exit strategies. Of course, this relates to the forced removal after temporary protection ends, but if this is the only way is to integration in the host societies and voluntary return, then we need to also talk about what will happen and how the Commission and the Council will decide on forced removals. So the first principle that I want to voice is the prohibition of collective expulsion provided under Protocol number 4 of the European Convention on Human Rights, which means that the cessation of the group status, such as temporary protection status, cannot lead to blanket removal issues. A violation of the collective expulsion may occur when return orders are issued as blanket measures, derived solely from termination of a general protection scheme. So Protocol number 4 of the ECHR requires removal procedures to guarantee a reasonable and objective examination of each individual case. Now, another quite important rule is that effective access to asylum. Under Article 17 of the directive, beneficiaries must retain the right to seek asylum. This is set in stone. And applications of temporary protection beneficiaries, international protection applications, of course, must be decided on the merits once temporary protection regime ends. The European Court of Justice just reaffirmed that member states cannot declare applications of international protection, including subsidiary protection applications, inadmissible solely because a person is enjoying temporary protection at the moment. So access to asylum is a right of all temporary protection beneficiaries. As I mentioned, the principle of refoulement is wholly applicable in both exit strategies and afterwards. So compliance of Article 2 and 3 of the European Convention on Human Rights necessitates a rigorous ex-nunc examination of individual risk before any removal. So the court requires authorities to assess the foreseeable consequences of removal based on the destination country's general situation and the person's personal circumstances. This is a critical point, and I think we need to think about the principle of refoulement and ECHR related obligations of the member states as well. A recent case law from the European Court of Justice is important. It's Kaduna decision. It says member states are precluded from issuing return decisions while the lawful stay of temporary protection remains valid. So member states should wait until the end of temporary protection to decide on removals, but again, to respect by the procedural rules stemming from Articles 2, 3, and 13 of the ECHR and also EU law, there should be individual decision-making in terms of removal in asylum. And this will bring quite a backlog to national asylum systems and create very much issues for migration authorities because they need to do this individual assessment once temporary protection ends. To avoid all of these, what is ideal is the most effective approach is collective transition. Once again, all beneficiaries should be transitioned as a group into a stable residency status or granted international protection status collectively. We have done research with Dr. Nick Tan and published it in a number of articles. And when we analyzed EU law, there is nothing in EU law in the Procedures Directive and Regulation, forthcoming regulation, and Qualification Directive and forthcoming regulation that EU member states can apply accelerated procedures that leads to positive decisions granted to Ukrainians. So although individual assessment is a requirement under EU law, you can still, and member states can still follow accelerated procedures for applications coming from temporary protection beneficiaries. So this is still a possibility. You can transition to another international protection status on a group basis. But if these are not possible and feasible, as I mentioned, a vital alternative is breach statuses, 24 up to 24-month breach status granted ex lege to all current beneficiaries, which can allow for staggered processing, prevent asylum system overload and backlogs. By institutionalizing look-and-see visits, as also recommended by the Council and the Commission, this breach can ensure return decisions are fully voluntary, avoid the Hobson's choice, in the words of the European Court of Human Rights, between return and destitution or prolonged detention. So unlike current Council recommendation based on Article 25 of the Temporary Protection, 21 of the Temporary Protection Directive, this bridge should apply to all temporary protection beneficiaries, not be conditioned upon registering to a voluntary return program. This can ensure none of the vulnerable groups are left behind. Thank you.
Thank you, Meltem. So at the end of the session, there'll be a wrap-up where Elena and Meltem can perhaps pick up on any outstanding issues, but I also wanted to bring our audience into this conversation. And so we have some questions already for both Elena and Meltem. And if people want to intervene in person, I think the group is not so large. I think that can work as well. But I'll begin with the questions already been asked, which there are 3, and we'll deal with those ones first. The first is a question to Elena from Jan Schneider. And Jan asked if you could briefly elaborate on member states' appetite to introduce any humanitarian, be it temporary or not, solution for vulnerable persons or groups, such as the elderly and disabled, but also single parenting mothers with little opportunity to participate in the labour market due to parenting issues or psychological issues or other issues. So is there any forerunner, any particular idea from the Commission, and has DG Home identified or any good practices in any member states that you could share? For Meltem, there's a question from Catherine, who asks, and I think it's really just for clarification, there's a lot of echo on Katrine's line, and so she could ask if you could repeat what you propose as Plan B of the 2 main solutions, international protection or durable residence. So that's really for people to overcome internet difficulties. And we have a question from Elvin, and Elvin asks again for Meltem, how do you see naturalization perspectives of temporary protection beneficiaries in the future? And Elvin says, well, of course, naturalization rules are determined by national legislation, but can we see a common approach or policy at the member states? So we'll take those 3 questions first, and I can see other people have got their hands up. So maybe if it's okay, we'll go to you first, Elena.
Yeah, sure, no problem. So thank you very much. I'm rereading the question in the chat. the solution with too little opportunity to participate in the labor market. So when it comes to the appetite, well, first of all, the council recommendation when it comes to vulnerable persons, I think the category that we have to look really in details here is those persons who do not fall under the crack, meaning that, for example, when persons who are unable to travel, the directive already provides, and this is a shall clause, that they should remain in the member states, basically with the extension of the rights of temporary protection. So here, when I refer to vulnerable persons, I tend to look more, for example, to persons who on one side do not manage to do a transition to other statuses, and on the other side might present vulnerability that basically hamper them to return now to Ukraine and to help with the reconstruction. One example could be, for example, unaccompanied children, or could be elderly person who in principle would be able to travel, but that in practice will not be able to help with the reconstruction of the country, be it because they don't have the skills, be it they, reduce mobility, etc. In these cases, so what has been emerged so far, I would say when it comes to this specific group, there will be perhaps the majority of member states who will follow the rights under the Temporary Protection Directive, also because legislatively speaking, is also more convenient for them to, especially for certain member states, to simply prolong temporary protection as it is now, rather than, for example, establishing a new residence permit or another residence permit. So I know for sure that there will be some member states who will simply prolong temporary protection as it is for this group of people. There are some other member states, being honest, of course, that might resort towards permits on humanitarian grounds, and this will be in a way a bit of the problem, because you also want to avoid that the same person basically with the same rights under the temporary protection, just because they reside in one member state or the other, they will have access to different rights later on. The forerunner idea that I've seen actually so far that is taking a bit more impetus nowadays is actually this dedicated residence permit, because of course the information on Poland and Czech Republic are already public in a way, because this is a development that this has been undergoing in these two countries for quite some time. But to anticipate, but of course not to share too much, there are other member states who will also go towards this type of solution. And normally this solution would also cover the vulnerable person. So the same permit that is given to a person who is engaged in the labor market will also be given to a person who is vulnerable. So this is, I would say, the type of permit, the type of solution that has been emerging in the past months. When it comes to any particular idea from Commission, here we always come back, unfortunately, to the fact that when it comes to issuance of residence permits, this is a competence of member states. And this is why I said at the beginning, and this is also replying to one of the points made, there is no legal basis for EU residence permit. I think we all would like these people to have exactly the same permits across the EU. I mean, this will be the easiest solution for everybody, that member states don't have to resort to different solutions, that we don't have to check with member states which access to right after temporary protection and also during temporary protection. But this is unfortunately the situation that, legally speaking, we are in. This is the issue. So when it comes to any particular idea from the Commission, well, our idea is, of course, to continue working with member states in order for them to keep the same rights, or at least similar rights under temporary protection, to those who will fall under the cap after 2027, which is the current end date of temporary protection. When it comes to good practices, so this is what I've seen so far. Personally, this what we call omnibus solution. So this is, I would say, the main thing that has emerged in the past months. I don't exclude that other type of solutions will emerge in the coming months. Conversely, I think there is less appetite when it comes to transition to statuses based on the EU Legal Migration Directive, even if it's just now there is a provision for this gap. In principle, this will not cover, of course, vulnerable persons, because here we're talking about students and researchers, single permit and blue card. So vulnerable persons will unfortunately not be covered by this anyway. So when it comes to those, this is the idea that some member states have been developed lately. Thank you.
Thank you, Elena. So Meltem, over to you.
Yes, thank you very much. Catherine's question, well, I advocated, and I have been doing this in a number of reports and articles. The first, I would say the first choice should be collectively transitioning into international protection based on EU asylum instruments, or collective transition to a uniform, ideally, resident status in the member states. Now, Elena mentioned, for instance, it is not possible because the EU has not have a competence to introduce such a uniform resident permit, but we didn't see a mention of uniform resident permit in the Commission proposals of June 2025 or the Council recommendation. The Commission and the Council just says, if you want to integrate temporary protection beneficiaries, use the national resident permits or the EU migration instruments, but it doesn't really provide guidance on who should be granted. I think this is a vague point that I have identified. And because of the echo, what I have proposed as Plan B is this. I have been working on a new article where I am proposing bridge statuses to make sure once temporary protection ends, people up to 2 years can decide on their future, whether to stay or whether to return. They can do look-and-see visits, they can apply for asylum, they can get legal help to which status to apply. I think this transitional status, also in some ECRE reports, I have seen this bridge statuses as well. These are recommended so that people can make improved choices. Now, the Commission does this, and the Council recommendation, based on Article 21 of the directive, saying that for those registered to voluntary return programs, 1-year extensions of statuses can be possible, but this is conditional on registering to the voluntary return programs. I am arguing that this should not be conditional. This should be provided to all temporary protection beneficiaries once regime ends. This, I hope, is a good response. Shall I move on to the second question, Andrew, or would you like to?
If briefly, if possible, because of the questions.
Alvin mentioned about naturalization. Of course, this is the competence of the member states, but I have known, because I have been working on temporary protection for more than 15 years now. For instance, in Ireland, the time requirement for citizenship has already been passed for many Ukrainians, but because they're on temporary protection, whether we can count the time spent on temporary protection among this required time is problematic. I have heard this from some Irish colleagues working on the issue, but we know that for some member states, even the naturalization time limits may have been passed, and for some, like Italy, 10 years is required, if I'm not mistaken. So we need discrepancies on naturalization conditions. We don't have guidance on this issue as well. So this is an important gap, I think.
Thank you, Meltem. So we got 4 more people who'd like to ask questions, 2 in person and 2 in the chat. I think that will give us, that's all the time we've got for Q&A. So to take these 4 questions, and please ask the questioners to be concise if at all possible, so that everybody gets a chance to participate in the conversation. So first of all, Letitia van der Venne, you'd like to ask a question?
Thank you very much. Thank you for organizing, and thank you for the rich discussion. I work for PICUM. For those who don't know me, I work for the Platform for International Cooperation on Undocumented Migrants. And I basically wanted to thank first, of course, for the guidance that the Commission and the Council have adopted last summer, because many NGOs and many people were asking for it for a very long time. I understand, of course, that there's discussion on the content, but I have 3 specific questions. I hear a lot of talk on transition into other statuses. We have also very conscious of this. But there are still people arriving, of course. We still have, on average, 40,000 people arriving. So if the TP ends, what happens to those new arrivals? Assuming that, of course, that continues. A second question, last week I was at an event where the Special Representative Ylva Johansson spoke, and she mentioned appetite for a further extension of temporary protection amongst the member states, potentially with a different scope. There is nothing on paper yet that I've seen anyhow, but the different scope would be potentially excluding certain regions of origin. And I would love to hear both from Elena, but also from Meltem, perspectives on this, of course. And then a last point on specifically voluntary return and reconstruction programs. I had heard that there might be maybe guidance coming or proposal or plan. I was just wondering if this was coming soon. Thank you very much.
Many thanks, Letitia. So Helena Dovhan, I hope I'm pronouncing your name correctly. Apologies if not. So over to you, Helena.
Hello, everyone. First of all, thank you very much for such a wonderful meeting where it's possible to discuss temporary protection. Let me first of all represent myself. I'm a Ukrainian legal scholar under temporary protection in Italy. So it's my personal interest to understand the future perspective for all of us. And first of all, I need to say that temporary protection in books and in directive and the temporary protection in action is absolutely different things. It's my personal experiences and experience of our very big Ukrainian community in Italy. And I would like to, if I may, to comment some ideas about our future as a Ukrainian community in the EU. First of all, it was mentioned about the possibility to transition to subsidiary protection or asylum. There are already cases in Italy when people convert their temporary protection permission to these two and other types, but they are not very good for us. I will explain why. Because as you know, during the war, for example, men, they are forbidden to leave the territory of Ukraine. If women, because our community consists mostly of women with minors, apply for these types of protection, we will be limited in our possibility of free movement and to visit our husbands, our fathers, our sons. And for us, it will be a personal tragedy. So it's not the best solution, because we are not here as then representatives of other migrants from other countries in a whole family. We are here women with minors, most of us. Second, it was about the long-term residents. In a week, my colleagues and I, we will open a legal clinics for Ukrainians in Italy. And one of the most popular question asked by the people who already are on list for these legal consultations about the long-term residence and perspective of this application in our case. For example, my personal situation, I have already residence here in Italy, and after the March 2027, I'm also thinking what to do, whether to return, whether to stay here. It depends, of course, on the situation in my country. And if to stay here, for example, to which type of permission I can go on to move, to convert. And for example, many people in all our groups, and we have a lot of groups very well administered in social networks. The main question is, for example, in Italy, I don't know about other countries, but in Italy, whether it's possible to use already 4 years of residence and plus 1 year the next year in order to apply for this long-term residence. Why not? Because we already pay taxes here. Most of us work here, children go to school, so we are integrated. Even if in Italy there is, I need to mention it, there is no program of integration of Ukrainian refugees, contrary, for example, to Germany, or if to compare, for example, with Poland or Czech Republic. In Italy, you just receive a plastic card and you need to organize your life by yourself. You don't have any assistance. It's about long-term residence, and in this context, I would like to ask Elena whether it under discussion such a possibility for us to move to this to apply for this long-term residence after 5 years of our life in EU countries. And the thought and the last point, it was mentioned many times by all speakers about them participation of Ukrainians in the reconstruction of country. I prefer not to be so optimistic that most of Ukrainians will return. Why? Because where to return? If a house is ruined, if there is no electricity, I spent all winter in Ukraine, there is no, you know, all these conditions, no electricity, no heating at homes. We will not bring our children to these conditions under bombs, of course. And in this situation, what to do? To return to reconstruct, if our men are, in fact, and it's a well-known fact, like in prison in Ukraine, they're blocked in the country. We are not allowed to meet in the EU. So it's our situation. Sorry, maybe it's a bit emotional, but I'm a person under temporary protection. That is why, and I'm a lawyer, and that is why I know all this situation, our needs from inside, and that is why I would like to bring all this experience to you as a policy also makers, because we don't have, unfortunately, this dialogue, this direct connection with someone with whom we can share our experience and what we really need. Thank you very much.
Thank you very much for sharing that, Helene. It's very much appreciated. So, and we just have a question which I'd like to table because people who wanted to join the conversation. Just to summarize them quickly, we've got a question from Lena Vosliuta who asks a question for Elena, which is about specific provisions for young people or who are transitioning to adulthood, especially access to long-term residence rights, and any difference in how years would be counted. Thank you, Lena. Vladimir, if I paraphrase a question of Vladimir, he's asking if Europe, again, it's a question of the European Commission. It's making a clear decision on the types of categories of transitional residence permits. Talks about the fate of pensioners, whether with children, disabled people who do not meet the requirements for existing residence permits will be bleak, and movement, secondary registration is more of a forced situation where numerous attempts at integration destroyed by administrative barriers. That's come from Vladimir. Thank you for that question. And then finally, I'm sorry to land all these points on you, but I do want everybody's asked the question to get the possibility to contribute. And Alla Fedorova asks, interested in hearing your thoughts on the prospects for the protection of the social rights of vulnerable categories of temporary protected people who remain in host states after 2027. What scope of social rights could be guaranteed for these categories after the termination of temporary protection? In several EU member states, Alla says, where special residence schemes have already been introduced, such as in Czechia, the financial requirements appear to be relatively high. Do you expect that many individuals may turn to asylum procedures? So I would go back to, I think the idea now, go back to Elena to respond to those issues. There's some very big issues. Perhaps then and wrap up your observations, and then over to Meltem again to respond and to wrap up. So first over to you, Elena, please.
Yeah, thank you. I think you should have planned this for 2 hours, not 1 hour lunch right conference. I will try to go quickly, considering the number of questions. First, I will start with Letizia. So what about those who are still arriving when it comes to exit strategy if temporary protection ends in 2027? Basically, if they're getting temporary protection, which is still the case at the moment because they still fall under the scope, they will automatically, in a way, be covered by the scope of the Council recommendation, because the Council recommendation talks about persons enjoying temporary protection. I do see, for example, some, and here I would take the opportunity to address the elephant in the room, which is potential prolongation of temporary protection. I see a bit of issues and challenges of persons coming from the EU now, in case and the interplay with the Council recommendation, in case we will go that direction, meaning the prolongation of temporary protection, because that, especially if you start differentiating the scope, because that, what would be the time limit, or how you would assess, the scope to actually put somebody under the transition, or to put somebody who's just now benefiting from temporary protection, etc. So generally speaking, as the situation it is now, those who are arriving now and getting temporary protection will be automatically fall under the scope of the Council recommendation. When it comes to the prolongation, there might be a differentiation, yeah. Ylva Johansson said it. I was not in the conference last week, but I think I know more or less what she said. Again, legally speaking, it's the Council decision that determines the scope of temporary protection. So I don't exclude 100%. I mean, here we are in an exceptional situation that we cannot exclude 100% a single option. To be honest, I don't exclude the temporary protection might be prolonged. I also don't exclude we simply terminate in March 2027. I think we are all aware of the position of certain member states when it comes to especially restriction of the scope. Many military age, safe areas. These are the ideas that have been floating around. Look, when it comes to the legal feasibility of this, personally, I still have my doubts. So speaking as a Commission policy officer, we are still assessing internally how the legal feasibility of certain options will work. Because also practically speaking, if you ask me as a person, who does the assessment of the safe areas in Ukraine, which criteria, which is the basis, is that actually possible? Because the Temporary Protection Directive doesn't talk about how the scope is established apart from the Council decision. But we will also, of course, have to consider, several factors such as non-discrimination and, all these kind of things that, of course, at EU level we have to take into account. So when it comes to the legal feasibilities of these options, I will be a bit cautious, because it's true that they are floating around, and there are some associated countries like Norway, like Switzerland, and there was this proposal in Denmark to go to the same direction, but the situation that we face in the EU is much different. First, when it comes to the feasibility, because they don't have the same number of persons, and because we deal with 27 member states. So who is going to do this potential assessment of the safe areas? I have no clue, because if you leave it to member states, they will have different view. If you leave it to the Commission, I'm not sure this is even legally feasible, because I don't know where are the limits there. So to reply to your questions, there are conversations ongoing. Of course, as Ylva said, I think now it's a bit too early to actually say if this will take a concrete shape or not. The conversation with member states will continue on this. This I tell you, normally, as you know, if the Commission proposes a prolongation of temporary protection, normally the proposal comes around May, June, and the adoption of the decision comes around September or July, depending on the scope. If the scope is going to be different, it will require a bit of time and a bit of discussion, I'm assuming, on this. When it comes to the voluntary return programs, I'm not sure whether there will be a guidance. We are, I don't have the possibility to share too much, but we are testing with some member states how this will work in practice. I'm not sure like how the voluntary return program will work in practice between the member states and Ukraine, because of course there is the second part in Ukraine that needs to work as well, because as also Alina said, I mean, you have to go back and help with the reconstruction when there are, facilities and conditions to do so, and money and funding for doing so. So this is what we've been working on as well with the GNS, which is the service responsible for the external part of this action. I am not sure whether there will be concrete guidelines from the Commission, but I think it could be a possibility also because the Council recommendation is a bit broad when it comes to this voluntary return program. There simply says in the recommendation that we have to have the same parameters, the same duration, etc. So this is something that we've been working on with member states. So I don't exclude that perhaps in the future there will be some developments in this sense. When it comes to the long-term residence directive, the position of the Commission, the Commission proposal. The long-term residence directive, the negotiations has been on stall for quite some time, and I tell you, not just because of temporary protection. So there are many points that have to be considered there. The role of the Commission is to also work together with the co-legislators, but at the same time, if the co-legislators don't move forward, there is little that the Commission, I tell you that the Commission is fully available to the Council on one side and to the Parliament on the other side to actually restart the negotiations on this file. At the moment, this is not the case. I think this is a very political file. This is very sensitive, and I don't exclude, if you ask me personally, I don't think that this will be taken up in short time. The situation as it is now is that beneficiaries of temporary protection are excluded from the scope of all the EU Legal Migrations Directive, not just the Long-Term Residence Directive, but of course that will be the most applicable one in this case, in a way. So if there are some gaps that some member states take to cover the gaps, to provide for a legal breach, is because they provide for more favorable conditions, which is something that they can always do, but that is not in the legislation. Because at the moment, the situation that we are confronted with now is that persons with temporary protection cannot have access to long-term residence directive. Unfortunately, this is the legal situation we are in now. And when it comes to the return to Ukraine, first I actually wanted to remark one important thing. There is no recommendation, no indication from the Commission. I speak for the Commission, of course, indicating that we will plan forced removals from forced return to Ukraine. This is absolutely not the action that we want to take when it comes to forced removal, especially because if, of course, the asylum is there, principle of non-refoulement is there, so we are not going to forcing people, to return to Ukraine. At the same time, there was a point, I think, that also Meltem brought up when he says that she doesn't agree with the fact that we will develop voluntary return program, and basically that it will be subject, the action it will be subject to the enrollment in a voluntary return program. Here, the idea is to provide for a coordination transition out of temporary protection. Again, be it transition, be it return. We're not forcing people to return to Ukraine. At the same time, if these people decide that they want to return to Ukraine and help with the reconstruction, I think it's very important, actually, that we have a coordinated approach. And you need to know who wants to be enrolled in the voluntary return program and return eventually to Ukraine to help with the reconstruction. But this is important not just for the member states, but also for the people. And when it comes to the duration of the voluntary return program, because of course one could think, there's a voluntary return program, so they are obliged to return. First of all, if you want to enroll, you enroll. If you don't want to enroll, you don't enroll. At the same time, the duration of the voluntary return program is 1 year at the moment. The Council recommendation doesn't exclude that this duration can be extended based as well on the situation in Ukraine. And this is also the legal basis for extending temporary protection, because the directive itself doesn't say 3 years. Actually, there are some public documents from the Council and the Parliament from the 1999-2000 that they were actually thinking about 5 years, not 3 years, but neither 3 years or 5 years made it in the final version of the directive. So the legal basis is the condition in Ukraine. If there are reasons for temporary protection to persist, if the safe and durable return to persons to Ukraine can be done, then temporary protection will end. If there are reasons for temporary protection to persist, temporary protection can be extended. So this is the situation when it comes to the return. And when you mentioned as well the part on free movements, I fully agree with you. I mean, this is something that that of course in the Council recommendation and the frequently asked questions from 2022, this was also at a bit of an emphasis, bit when it comes to returning to Ukraine and then also return to the host member state. So on that point, I fully agree with you, and this is also the action of the Commission for sure. I don't think I covered all the points, but let me know if there is any other important point that I should address. Thank you.
So many thanks, Elena. You covered a lot of ground there. It was impressive. So thank you for that. And Meltem, for you to wrap up, respond to any issues that you'd like to.
Right. I will keep it very brief because we are, we should stick to the time. Well, I must say, in the drafting works of the directive, there were indeed, as Elena mentioned, different timeframes suggested by the member states. 5 years was on the table, but also 1 year was also advocated by some member states. 3 years was the compromise. So it was actually in the working documents that 3 years was accepted. I had to have many discussions with all the academics working on Temporary Protection Directive, though not many at once, and none of them actually argues that 3-year time limit can be disregarded. And this is an academic point that I'm very clear. I have read all the drafting works and working documents. 5 years or prolonging extensions, yearly extensions is not there. That's one point. The second, I welcome the comments of Elena saying that we will not force return. That's a very good thing. The Commission stands saying that forced returns are not the way to go after temporary protection regime's termination is a very good thing. But I know from my exchanges of some member states and the heads of national migration agencies, some member states are ready to stand on to actually issue removal orders once temporary protection regime is over. I know some member states just favor residency or, help people to stay, but some member states will issue return decisions once temporary protection regime is ended. And I think it is very important by the Commission and the Council to make that point clear, because although binary choice being integration by residency permits and then voluntary return, informed voluntary return is a very good pathway in theory, I know from a fact that some member states will want to issue return orders saying that, okay, once temporary protection regime is ended, we do not see the reason anymore. And then all asylum applications will overwhelm national asylum and migration capacities. That's something I know from looking at how member states in 1990s handled temporary protection statuses and the return of Bosnians and Kosovars. This will happen again, and I can assure you from historical examples, this will be an issue for some member states. And finally, just one, there was some question about social rights of vulnerable people who once temporary protection regime is ended. I think this is very important because although Ukrainians may feel they do not prefer international protection status, as one pro compared to residency permits is that international protection gives you social assistance under EU law and resident permits may not. This is an issue to consider because each resident permits under national laws come with different conditions and rights, but EU law international protection statuses come with set in stone rights and beneficiaries for the protection beneficiaries. That is one thing to consider. One final comment, I think Leticia made a very good point. Administrative law-wise, I think for some groups to be designated as eligible for temporary protection, it needs to be a EU-wide termination of all the temporary protection regime first. I think that's the only way that the directive could be activated for a second time. I don't think that you can just say we are terminating it for some groups and the others can continue. That's one of the administrative law issues that I should mention from my experience working on the directive. Thank you.
Many thanks, Meltem. I think, as Elena said, this is a conversation of carry on, but our intention here was to produce a focused dialogue between policy context and research. I think we've got a great example of how that can be done. I'm really grateful for Elena and Meltem for sharing their time and their expertise. It's been a really valuable and important session, and I hope that people who've participated will also engage with the work we do in the Migration Research Policy Collab. So the project we're engaged with, what we want to do is build stronger links. This is an ongoing conversation. We invite you all to participate in this, keep up with our activities, and also share ideas that you might have for things that you think we could do, issues we could engage with. So many thanks to everybody for participating, and wish you a very happy rest of the day. Thank you, and hopefully see you soon.